This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
And greetings, welcome back, everyone, to another episode of Dish and Dirt. I'm your often opinionated, rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia and Lexington offices today of Blair, Cato, Pickren, Castellan. This, the third week of July 2025. Well, as promised, last week we did knock out the South Carolina Realtors Association contract. We went over all the new terms and are so far very well received. So we're very excited about that. CCRA does have a new contract coming out, but it has not been finalized by the board. We are going to wait a little bit longer before we go over the changes with the CCRA contract. I'm hoping that'll be in about 2 weeks that we can come and discuss those changes. They're very similar to SCR. It's not going to be a big, massive change, but we will go over those as soon as we have word from CCRA. All right, last week, I did mention FinCEN. FinCEN will not go away. It continues to come back. Every time I think we have finally killed off this terrible bill, this terrible law, the next thing I know, Erice Lybrand's in our attorney meetings telling us it's not done. Of course, anytime we have a very difficult technical question revolving around title work or title issues or anything involving the government putting new regulations on us, Erica's our go-to person. She is Blair Cato's title attorney. You have seen her multiple times on Dish and Dirt. She is going to join us again here today. Erica, thank you for joining us to talk about this never-dying beast called FinCEN.
Sure. Thank you for having me.
You came on about a year ago. I know the real estate agents will remember you talking about FinCEN. Why don't you take a few minutes to just recap what it was back then we were talking about, bringing us to where we are today. I personally thought FinCEN had died. It won't die. It keeps coming back. What the hell's going on?
Okay, so FinCEN is the Financial Crimes Enforcement Network. It's an agency type of entity for the federal government that it puts together rules and regulations to enforce certain policies of the government in terms of different things that need to happen in order to make the laws work the way that they're intended to work. What we were talking about last year and all the way up until the very beginning of 2025 was the BOI rule, or the Beneficial Ownership Information Rule. That had everybody in a tizzy because there was going to be some reporting requirements associated with ownership of entities, LLCs, corporations, partnerships, things of that nature. And that one did sort of go away. And it went away in that U.S. corporations, U.S. LLCs, U.S. entities are now exempt from reporting requirements. It's still out there. The BOI rule is still out there, but it's only relevant to foreign companies.
If a real estate agent owned an LLC, they were going to have to fill out this massive report saying who they are and everything they owned and all kind of stuff.
That's right. And again, that you just said it. It was the requirement of the LLC itself or the company itself to make the reporting associated with their beneficial ownership. So anybody who owned, I want to say it was 20% or more in a company, was going to have to report their ownership interest in that company. And we were not going to really necessarily be involved in that, but for maybe our practice where Marshall Minton and her associates are creating entities for people, our office really wasn't all that involved with that particular type of
and that died. That died. That's no longer having to be done, correct?
That's right.
All right.
So this is a completely different rule. This is what we're calling AML. It's the anti-money laundering rule. And it takes effect December 1st, 2025. It has not been done away with. In fact, everybody is sort of on the train right now that thinking it is, in fact, going to go into effect. We don't anticipate at this time any delays in the implementation of this rule. We are operating as if we will be having to report under this new AML rule effective December 1st, 2025.
And you were just up in Washington, D.C. recently speaking with many senators and congressmen. And as I understand, you were saying the general feeling up there was they didn't even know about it. They thought that it had gone away. They're kind of was as clueless as everybody else on this. And they're the ones who passed the law.
That's right. That's right. Well, so this is, of course, a rule that's been promulgated by an agency. So a lot of the legislators that we were meeting with were under the impression that it was the same as the BOI rule, the Beneficial Ownership Information Rule. And this is a completely separate rule. So as soon as I said FinCEN to these legislators, they were like, oh, we dealt with that already. And I'm like, no, this is a different rule. A lot of them were shocked about the rule. A lot of them were shocked at what the rule is requiring, and a lot of them were willing to try to help us at least try to narrow down the focus of the rule. But so far, from what I understand, is there hasn't been a lot of movement with regard to any kind of narrowing or putting any thresholds on the rule.
It actually might be almost too late at this point, isn't it? And this rule's starting to come into play in just a few months.
Rule is effective December 1, 2025. So what that means is that any closing that happens or any transaction that happens on or after December 1, 2025 will have to be subject to this AML rule. And for what that means for us is any closing that we get, any contract that we get for a closing that is to take place after December 1st, 2025 will be potentially subject to this reporting rule. So we're talking about contracts that we're going to get probably starting in October. And, we're in July. We're a couple months out from having to start the collection process associated with the reporting under this rule.
Tell us about this onerous rule. You told me a little bit about it in an attorney meeting, and I just about lost my mind over this. I cannot believe what the rule requires and then how much work it's going to require, which thus means fees for this are going to be outrageous as well.
That's right. The anti-money laundering rule, it requires settlement agents or other potential parties to the settlement itself, the closing, to file a report with the Financial Crimes Enforcement Network, or FinCEN, with regard to any non-financed transfer of residential real estate to a legal entity or to a trust. Like, just to break that down a minute.
Yeah, break that down.
Each transfer of real estate, so even if it's just a deed and there's no sales price or nothing being paid for it, that is a transfer of real estate. Each transfer of real estate to an entity or to a trust, so we're talking about LLCs, corporations, partnerships, or to a trust, so mom and dad's revocable living trust, where the transaction is considered non-financed. We're not just talking about cash here. Non-financed also includes any loans that are being obtained for the purchase of the property that are from a non-institutional lender, an investor or a hard money lender or mom and dad who are giving you the money to buy the house. If that lender does not already have federally required anti-money laundering requirements, that transaction will be subject to this reporting requirement. We're not just talking about cash. We're not just talking about LLCs. We're talking about any deed, transfer of property to any type of entity or trust that is non-financed, cash, hard money lender, investors, mom and dad type of lenders.
So any real estate let me break that down. Make sure I think I got it now. Any real estate transaction we do, or any deed transfer, meaning that a real estate agent comes in or their client comes in and says, I want to move this from my personal name to my LLC for protection, or I want to move it from my personal name to my trust for estate planning. They're going to have to do this FinCEN reporting. Anytime we do a closing that's a cash closing, or even a closing where mom and dad loan them the money, we did a little note mortgage for mom and dad or a family member, or they're using some non-traditional financing. So any investor is going to have to do that. If they're using some type of third-party money that's not a Bank of America or a Wells Fargo type bank, but even it could be some lenders that just don't have anti-money laundering processes in place that the federal government likes. So it could be some credit union in the middle of Arkansas. We might even have to do this reporting.
That's right. And probably more likely, if it's a credit union, it's probably going to be subject already to the federal requirements for the anti-money laundering stuff. What we're talking more about are the real estate investment type banks, the ones that are not federally insured, the ones that don't already have the requirements under the federal government to have these anti-money laundering policies and procedures in place. We've been seeing an awful lot of these lately, what we call hard money lenders, real estate investment type entities that are financing the purchase of real estate. All of those types of things, despite the fact that that would not be a cash transaction, it would be considered non-financed for the purpose of this rule. Now, I do want to say something real quick because you did just mention something that I wanted to make clear. So a transfer to a trust does count. We would have to report any transfer to a trust, but there is an exemption for transfers to a trust where the person who is transferring the property is also the sole legal owner or the legal owners of the trust, being the settlor or the person who has initially set up that trust. So for estate planning purposes, if you own some property and you transfer into your A's revocable living trust, then that would be exempt and we wouldn't have to report. But if you, A, and your spouse, B, own real estate and you both convey into just A's revocable living trust, that could be potentially reportable because B doesn't also own the trust or is not also a settler under the trust. So there's all types of things that could make a transaction either reportable or exempt. And that's really part of the whole issue with this rule is it's going to take a lot to know whether or not we need to be reporting.
The transaction that a real estate agents mostly would be involved in that would require the reporting is a cash deal.
Cash deals, or like I said, deals that are financed by an investor type entity that's not a
basically,
federal.
anytime they're working with an investor, more than likely they're going to have to, this is going to be part of it. But, right now we're seeing a proliferation of cash deals in our market. I saw something the other day, I think NAR put out that the number of cash deals that we are dealing with in real estate is at an all-time high. I mean, it used to be rarity that you would have a cash transaction in real estate. And now I can't remember the number, but I want to say it's well over a quarter of the transactions are cash
It's a
transactions.
huge number. We see it. And also when I was in Washington, one of the things that they shared with us was information from across the country about the number of cash transactions in certain states across the country. And we were certainly towards the high end. Obviously, we weren't the highest number of cash transactions, but for our little state, we were up towards the higher end. This is certainly one of these types of rules which is going to affect our market.
Well, we know the reason that is. We have a lot of people moving in from California and more expensive places, New York, and they sell their house and they have the cash from that house to come down here and buy a much, much cheaper house and pay cash for it. And that's why we're going to see that. Before we get into the actual reporting, what's the purpose of this? I mean, this reporting, before we say what it is and how onerous it is, what is the purpose of this FinCEN in the first place?
The purpose is, like I said, it's called the anti-money laundering rule, right? The government wants to collect information that's going to be useful to them in criminal or tax investigations and to, gather intelligence to protect against international terrorism and other potential risks to the citizens of our country. They've realized in prior efforts that their investigations were being thwarted by the fact that they couldn't get banking information. A lot of times we have foreign bank accounts that people are using that have secret bank numbers and things like that the government wasn't able to get access to. And so it thwarted their investigations. It caused their investigations to sort of fall apart. This rule would require the disclosure and the reporting associated with these accounts, which takes that issue associated with their investigation sort of out of the way.
If Jane Doe is buying a house from John Doe in Columbia, South Carolina for $200,000 in cash, and this has to get reported to the federal government, there's actually somebody in the federal government is going to oversee this transaction again and review it. That's what they want us to believe. I mean, I don't believe that.
Well, I think what the idea is to have the information available in the event that there's any patterns or courses of action across the state or across the country involving these entities, that they would raise potential red flags, and then the government would have the information available to them to launch the investigation without having to try to find out additional information from the individual parties or potentially, like I said, be thwarted by the fact that this information is unavailable to them.
They think a cartel is money laundering drug money into real estate. They're not necessarily looking at every transaction, but once they start investigating that cartel for the money laundering, then they can go into this information, find it, and use that as their way of stopping it.
That's right. And they did report that I think they said something like 86% of closed cases that involved, illegal transactions associated with maybe money laundering or other criminal enterprises did involve some manner of real estate. And that's why this has been a very high priority for the federal government, is to try to figure out a way that they can use these transactions to gather more and to potentially put these people behind bars.
So it actually does seem to have some sense to it. I mean, to me, if they're going to sit here and look at every single transaction, that every time Gary conveys his property to his wife Emily, they're not going to look at that. That seems to be ludicrous. But if they are going to use it after they're actively involved in some investigation against a criminal organization or some type of money laundering case, and it does give them access, I could see where that actually has some sense.
Right. And
But
again,
we'll
remember,
see.
we're only talking about entities and trusts. If Gary is conveying property to Emily, that's not going to matter. It's if Gary is conveying property to Emily LLC, right?
Ah,
And so often we're having people who are conveying to LLCs or to trusts or something along that lines, because the whole idea there is to essentially shield the public from information associated with them individually. And unfortunately, this rule is going to kind of put the government back into this.
That's one of the key points I think I missed, and I want to make sure the audience didn't miss this. It's not just cash transactions or transactions with unregulated, for lack of a better word, lenders. These third party type lenders. It has to be an LLC involved in the transaction. So
Has to
it's
be an
not
entity or a trust.
some type of LLC, entity, trust, corporation, company. It's not just John Doe pays cash for Jane Doe's house. It would have to be John Doe paying cash for Jane Doe LLC's house, or John Doe LLC buying the property from Jane Doe individually. So is it both ways, buyer
No,
or seller?
it's just
No,
the buyer. It's just the
just the
transferee that.
buyer's an LLC.
Yep.
Okay, so that's a
Yep.
very important thing. It has to be a buyer that's an entity paying cash. There's two components there: paying cash or a non-traditional lender, and then it has to be a corporation or entity has to be the buyer. Very important.
Yep. It also has to be a residential property. There are some additional things with that particular requirement. If it's an empty lot, it may still qualify as a residential property if the intention is to build a residential home or residential structure on it. It also, if it's a 1 to 4 family, so if, let's say it's a townhouse with 2 houses, then that would qualify for reporting. But if it's a 15-unit apartment complex, that's not going to qualify as a 1 to 4 residential, and that's going to be exempt from reporting. 3 things. It has to be a transfer to, a sale to, or a transfer to an entity, LLC, corporation, or partnership, or to a trust that is not otherwise exempt, like we talked about, for estate planning purposes. And it has to be cash or non-financed, meaning not an institutional lender involved, and it has to be residential property, 1 to 4 family.
Okay. Well,
I will
this
say there is one other thing. It can be potentially a commercial property if there's also like a residential unit attached. If it's a shop that's being sold with an apartment above it, that would qualify for.
Wow, just trying to figure out what qualifies and what doesn't seems to be a full-time job. Do you think this is going to discourage people from putting properties in LLCs and partnerships and company? I mean, one of the things that we as lawyers often do with investors is tell them to put the property in an LLC, to take it out of their name for, especially if you're going to buy a house and rent it, or even buy a house for your kids for college. We're telling them to put those in LLCs. I could see where a parent would come to Carolina or Clemson or Coastal Carolina, buy a house, pay cash for it, put it in an LLC because they don't want somebody to be over there drinking and get in an automobile accident and sue them individually. It's like discouraging this.
That's still a very important reason to maintain property ownership in one of these types of entities. Your liability as a property owner is an important consideration when you're deciding how to title a home. Whether or not there's an opportunity to take title as an individual and then convey it to an LLC, it's still going to qualify right now, like as the rule sits. There is no minimum threshold for the amount that's being paid for the transfers. Even a $5 or $0 transfer to an LLC, would still be potentially reportable. We're hoping that maybe the FinCEN provides for a threshold of 100,000 or 300,000. Something along that line, so that we wouldn't be having to report every single $5 conveyance into an LLC. I do think it's still very important to take into consideration your liability and the risk associated with owning property in your individual name, especially if it's being used for some sort of business purpose, rentals and things like that. I think it certainly may prevent people from doing that as part of the original sales transaction. Maybe they feel a little bit better about it being part of a separate transaction where it's just them individually conveying to their LLC and they're not having anybody else have to be involved in that. I don't really know where we go from here in terms of our advice to people. Like I said, I still think that holding title in an LLC is going to be better for liability purposes. And realistically, I know nobody wants to give the federal government their information, but if you have nothing to hide and you just own this LLC because for business purposes or for rental purposes or what have you, realistically, the information they're asking for is unlikely to be a big problem for you, I would think. But everybody's going to have to make their own considerations and risk assessments about how they want to proceed.
Let's talk about how onerous this is, though, because if it's just giving them my name and my social security number, okay, there's always that risk that somebody gets a hold of that information because you're going to have to give it to the law firm. The law firm's going to have to upload it to the federal government. There's always a tremendous risk anytime you have personal information that gets compromised in some way. We see it every day, whether it's a Target or the state of South Carolina when all of our tax returns got hacked by the Russians. They're very hackable. What is it what information are we having to provide? How onerous is it? And how much is this going to cost?
Well, it's exceptionally onerous. The current reporting form that they have developed has 111 fields. It requires settlement agents to report things that we don't currently ask for right now, like the full names, birthdays, citizenship, social security numbers for every beneficial owner of the entity or trust. That's somebody who owns 25% interest or more in the entity, and every individual who signs for the entity. So, for example, you have an entity that's owned by A and B, but you have somebody in your office that regularly signs. So C regularly signs, and there's a company resolution that authorizes C to sign closing documents. We would also need all of that same information for C, even though they are not actually an owner of the entity since they signed for the entity.
Does that include law firms who sign on behalf of builders and investors?
It does.
Wow. I have to provide my personal information if I sign for ABC Investor.
That's right.
Goodness.
What we're probably going to see is a whole lot less people who are going to be willing to operate as a signer who don't actually also own some percentage interest in the companies. The rule also requires settlement agents to provide the full name, date of birth, citizenship, and social security numbers for the seller or the transferor as well. This isn't just something that's going to affect the buyer entity of the buyer trust. When we have a reportable transaction, we also have to report that same information about the seller or the transferor as well. And that's part of our issue, right? Is that there is not currently an opportunity or an option for the reporting person to say this person refused to provide the information. So we either have to report it and fill out the form, or we're potentially subject to penalties.
So before we get into the penalties, how long on average does it take to fill out this 100 plus item questionnaire if you had all the information?
Sure. FinCEN themselves have said that it would take approximately an hour and 15 minutes per reporting. Whether or not that's sitting at the portal and typing in the answers on every field, I don't know. And I don't currently know whether or not there is a mechanism to sort of transfer the form information into their portal system for reporting. We're still trying to work out because some of these details have not actually come back to us yet in terms of the final number of fields and things of that nature. So, but they have estimated themselves it taking an hour and 15 minutes per report to enter into this information in their portal. That is just the entering of the information. That does not take into account the collection of that information within the system itself. So, we use a software system that collects information from our buyers and our sellers and all the rest of the parties to the transaction. And we put that information into our system. And then we're able to generate documents and things like that using that information. All of the information that's going to have to be reported is going to still have to be collected by our office as well. I would estimate a significant amount of time associated with someone from the settlement agent's office being involved in both the collection and the reporting
And
of
so
the information.
basically somebody's going to have to charge for this. That means a firm cannot work 2 to 3 hours gathering information without having a corresponding charge for that. Anytime we deal with one of these, somebody's going to get hit for hundreds of dollars, which makes transferring my deed from myself to my LLC no longer just the cost of the deed. Now it's the cost of a deed plus a FinCEN reporting. We're talking hundreds and hundreds of dollars more expensive.
Right. Absolutely. And, the thing is that this reporting really provides no individual or company benefit to the settlement agent. This is not a situation where it's like we can hire an individual, which is very likely what's going to happen. You hire an individual whose sole job is to collect and report the information as required by FinCEN. But the hiring of that person, the collection of the information and the reporting to FinCEN has no individual benefit to the law firm other than it prevents the law firm from being heavily penalized by the federal government. It's a cost of business that is not going to be obtained through any other means. And so really it has to be passed along to the parties that are subject to this reporting.
You could easily see upwards $300, $400, $500 for this FinCEN reporting per transaction.
It could be. I mean, at this point, we're still in that period of trying to figure out what it is, but it's certainly going to be a charge, and it's certainly going to be a couple $100s.
Two quick questions. Maybe two quick questions. What's the fine for not reporting it? We just say, screw it, we're not going to do it.
The individual transaction penalties start around $1,300 per transaction. They increase with, I think, some daily penalties. And then if you say, screw it, we're just not going to do it, then you can be considered to be somebody who is repeatedly failing to do your reporting, and then you get charged even more. And we're talking about tens of thousands of dollars in civil penalties, and also be subject to potential criminal liability as well if you straight up decide that you're just not going to do it.
So this is very, very expensive. I mean, there's just no way a lawyer can just say, well, we're just not going to do it. Or on this transaction, we're not going to worry about it because you're one of my best clients.
Right. And they do have the ability to audit the settlement agents or the other parties who are required to report under the rules. In this situation, what we'd be dealing with is you can get away with it maybe for a little bit, and then they decide to launch an audit because for whatever reason, this one settlement agent in Columbia, South Carolina isn't reporting anything, and they want to know why. And that's when you're really going to get popped with penalties and fines if they find out that not only have you been not reporting, but you've willingly been not reporting.
My fear in this from the very beginning is this, that people aren't going to want to do it. And so the lawyers that are following the law, because I guarantee you there's a lot of lawyers that have no clue this is even happening. And then all of a sudden it happens and the agents are going to say, well, I'm just going to go to this lawyer because that'll make us jump through this loophole. Is that an option?
It should not be. And I think you're right, Gary. I think there's probably going to be a lot of shops around the state who are not going to have a clue about this. Or they're going to know about it, but they're not really going to know enough to know exactly what they're going to have to be asking for and dealing with in terms of reporting and collection and that kind of thing. And, if somebody says to you, you can come over here and do the closing because I'm not going to report your transaction, they're violating the federal law. And do you really want to send your closings to somebody who's willingly violating federal law or is so unknowledgeable about the federal law that they're willing to take on that transaction without agreeing to do the reporting? It's a situation where, we hate it for the clients. We don't want to report this information any more than the clients do, but it's a requirement of the federal government. It is potential huge financial and possibly criminal penalties for not reporting and for willingly not reporting. And I'm not even convinced that we wouldn't have as lawyers some obligation to report other lawyers for willingly violating this. So I just don't, I would hope that that would not be the case, Gary, that people wouldn't say, hey, if you come over here and bring your closing to me, we won't report your transaction to the federal government, because I think it just can create a whole lot more problems across the board.
I don't want as a real estate agent to be involved in a federal investigation, because if ABC law firm doesn't do it and then all of a sudden the federal government starts investigating them, I think you're just asking to be involved in a federal investigation, which nobody ever wants to be involved in a federal investigation. Well,
Right.
Erica, this is not good. Hopefully we can delay it or something can happen. I don't know what can be done. I would advise people to reach out to NAR and see if NAR can use their lobbying power. One of the best benefits of NAR is their lobbying powers. We need all hands on deck here to try to delay this, or at least minimize it to a dollar amount. Erica, thank you so much for coming on and giving us this wonderful information. It's kind of that strategy. We come and piss off people and tell them all the bad news and then say, send Blair Cato your business. It's a great marketing strategy, right? I love it.
That's right.
All right, guys. Well, thank y'all for joining us for another episode of Dish and Dirt. If y'all come back again next week, and be sure to tell all of your friends and other real estate agents about Dish and Dirt, subscribe, like us, and come back again for another episode. Y'all have a great weekend. See you next week.